Hello, welcome and thank you all for joining us. My name is Dave Bowden, the news editor here at Ballotpedia. The coronavirus pandemic has affected so much of our society, including the government at the federal, state, and local levels. For example, the Supreme Court suspended hearing arguments of cases that were scheduled this week, which is the first time they'd done that in over 100 years, and we'll get into that a little bit more in just a few minutes. But shifting our attention away from coronavirus for a little bit, we thought that we would talk about the Supreme Court more broadly, take a look at the current term and where it stands, including some of the decisions that they've already reached so far. And in the past month, I think the Supreme Court has already designated certain cases that it will hear the next term. So perhaps we can get into that a little bit as well. So to help me take a look at all of this, I am joined today by Sarah Reynolds and Kate Garcella, who are staff writers on our elections team here at Ballotpedia, who extensively cover the Supreme Court. Sarah and Kate, thanks for taking the time to talk with me today.
Hi, everyone. Pleasure to be here.
Happy to be here. Thank you.
Okay, so let's start at the top of the subject and work our way down. So Kate, can you give us just a broad overview of the Supreme Court?
Sure, my pleasure. So the Supreme Court of the United States is the highest judicial body in the country and leads the judicial branch of the federal government. You may know it by its acronym, SCOTUS. The Supreme Court is the only court established by the United States Constitution in Article 3. All other federal courts are created by Congress. There are 9 justices on the Supreme Court: Chief Justice of the United States John Roberts and 8 associate justices: Clarence Thomas, Ruth Bader Ginsburg, Stephen Breyer, Samuel Alito, Sonia Sotomayor, Elena Kagan, Neil Gorsuch, and Brett Kavanaugh. The justices are nominated by the President and confirmed with the advice and consent of the United States Senate per Article 2 of the Constitution. As federal judges, the justices serve during good behavior, which means that justices have tenure for life unless they're removed by impeachment and subsequent conviction.
All right, that's a great foundation to get us started. As I mentioned in my intro, the court had an unusual change to its schedule over the last few weeks as a result of the coronavirus outbreak. So Sarah, can you give us a little bit more about that?
Sure. So the Supreme Court first responded to the coronavirus by closing to the public indefinitely. That occurred, that started at 4:30 p.m. on Thursday, March 12th. On Monday, the 16th, they announced that the court was postponing 7 hours of oral argument that had been scheduled for its and that would have begun yesterday. It would have taken place from March 23rd to April 1st. And there is some speculation that the court will also postpone its April sitting, but as of this webinar, they haven't officially made any announcements. The last time the court postponed arguments was over 100 years ago in October 1918 in response to the Spanish flu epidemic. And they also shortened argument in response to yellow fever outbreaks. And that was in 1793 and 1798. Oops, I forgot to mention. They also, so the court, although they're close to the public, they are still getting things done. A lot of the work at the Supreme Court goes on behind the scenes. So, for example, the justices held a private conference on March 20th, and they released orders, including 4 opinions and an unsigned opinion in a case that was not argued before the court.
All right, so that's really shows you the unusual nature of the postponement that the court announced just this month. Now, the Supreme Court calendar is organized into what they call terms, which is a word you'll hear a lot during this webinar, and it's the period during which the justices hear cases and they issue their decisions. And Kate, its timing is not too different from the school year that we're all pretty familiar with. Is that correct?
Yeah, that's a good way of putting it. So for its 2019-2020 October term, SCOTUS began hearing cases on October 7th, 2019. The court's yearly term begins on the first Monday in October and lasts until the first Monday in October the following year. The court generally releases the majority of its decisions in mid-June. So the court has agreed to hear 73 cases during its 2019-2020 term. The Supreme Court hears and reaches decisions in 70 to 90 cases each year. One case, Walker v. United States, was dismissed before arguments following the death of the petitioner, and that was in January of this year. So as you can see from the chart, the lower courts with the most cases before SCOTUS this term have been the 2nd and the 9th circuits with 9 cases each. 11 cases originated in state and district courts, and 1 case originated from the U.S. Court of Appeals for the Armed Forces. That doesn't always happen. It's a consolidated case, United States v. Briggs, consolidated with United States v. Collins.
All right, thanks for that breakdown. Now, the Supreme Court can issue decisions on cases known as opinions throughout the year, but they generally issue them more as the term goes on, as can be expected. In fact, there's usually a flurry of decisions that are issued in May and through the weeks of June. So, Sarah, how many decisions has the court issued so far this term?
Yes, May and June are usually the big decision months for SCOTUS reporters. We all know those can be crazy times. So as of today, of this webinar, the court has issued decisions in 17 cases. That's about 25% of the cases it's considering this term. And compared to last year, by this time last term, the court had released 22 decisions, which was about 32% of the cases they heard last year. So as I said, there are 17 cases that have opinions so far. That includes 10 lower court affirmations. So the court affirmed 10 lower court decisions. They vacated 6 and reversed 1. And then one of the opinions, as I mentioned earlier, was issued for Davis v. United States, which was not argued before the court. And there was another case, Mathino v. Malvo, that was dismissed after the court heard oral arguments, but before an opinion was released. So we're not going to get an opinion in that case this term. However, the Supreme Court did accept a case with a similar question for next term, which we're going to talk about next term later. And
okay. And I know one thing, avid followers of the court, legal scholars, whatnot, one of the things they track are the cases where the court reverses the decision that it gets from the court from which the case came. So do we have any data on that for this term yet?
Right, well, it's too soon this term to see if there are really any trends about the opinions, like are they affirming or overturning more decisions from one circuit or another? So we'll have to check back on that later this year, which Ballotpedia does. We publish data on SCOTUS reversal rates every year. And right now, we have data on reversal rates from 2007 to the 2018 term, which was last year's term. We'll have data for this current term probably in July or a little later this year. And right now, we know that between 2007 and 2018, SCOTUS released opinions in 924 cases. That's about 70 to 90 per year, as Kate mentioned earlier. 70.3% of those opinions reversed a lower court decision. That means 650 of the 924 cases were reversed, and 20.8% affirmed a lower court opinion. So those numbers one more time. 70.3% of opinions were reversed, and 0.8% of lower court opinions were affirmed. So during this time, 2007 to 2018, SCOTUS decided more cases from the 9th Circuit than from any other circuit, and the next most was the 6th Circuit, and they overturned a greater number of cases from the 9th Circuit, but a higher percentage of cases from the 6th Circuit, which I thought was interesting. And just geographic context, the 9th Circuit is like the West Coast. It has jurisdiction in Alaska, Arizona, California, Hawaii, Idaho, Montana, Nevada, Oregon, and Washington. And the Sixth Circuit has jurisdiction in Kentucky, Michigan, Ohio, and Tennessee.
All right, so that's a pretty interesting overview of reversal rates over a pretty long period of time. So now let's take a look at some of the interesting cases that the court has heard or is scheduled to hear in the current term. So Sarah, there's a closely watched case that the court has heard about abortion, is that right?
Yes, that's correct. Some of our listeners and readers might already be aware of this case, June Medical Services v. Russo from the Fifth Circuit, and it was argued on March 4th. June Medical Services is a clinic in Shreveport, Louisiana, and it challenged Act 620 in court. Act 620 is a Louisiana law that requires doctors performing abortions to have admitting privileges at local hospitals. And June Medical Services is arguing that this law is unconstitutional. So the litigation history, there's been some back and forth about some preliminary injunctions, and ultimately the Fifth Circuit ruled that Act 620 was constitutional. And while all that litigation was going on, SCOTUS held in Whole Woman's Health v. Hellerstedt that a Texas law similar to Louisiana's law was unconstitutional. So the court is going to decide whether the Fifth Circuit's decision holding Louisiana's law conflicts with SCOTUS's own precedent in Whole Woman's Health, which was decided in 2016. So something about this case is that in January, 207 members of Congress, that's 39 senators and 168 House members, filed an amicus brief arguing that June Medical Services didn't have the legal right to bring lawsuits on behalf of their patients. And the members argued that the Fifth Circuit's decision was correct, and that said that SCOTUS should reconsider past precedents established versus Wade and Planned Parenthood v. Casey, which were cases decided in 1973 and 1992.
All right, so this is going to be, I think, an incredibly closely watched case on this issue, and this is going to be a decision that will, I think, generate major headlines when it comes out. So thank you for that summary. Now, shifting gears to another case, Kate, there's an interesting one that forms a pretty solid foundation about the president's ability to either appoint or remove members of some executive branch agencies, right?
That's right. So BP's Administrative State Project Team, or TASP, they've been keeping a close eye on this case. It's SELA Law versus the Consumer Financial Protection Bureau, also known as the CFPB. This case came from the Ninth Circuit and was argued on March 3rd of this year. Briefly, the litigation history. In 2017, the CFPB was investigating California-based law firm SELA Law and put in a request for information and documents related to the investigation. SELA Law refused, and so the CFPB petitioned the Central District of California to enforce compliance. SELA Law challenged the CFPB's constitutionality under the separation of powers doctrine. The challenge was rejected, and SELA Law was ordered to comply with the CFPB. SELA Law appealed to the Ninth Circuit. The Ninth Circuit affirmed the district court's order, but granted a stay to SELA Law pending appeal to SCOTUS. Little side note here, the CFPB's constitutionality was also at issue in a different case during this time, a case before the District of Columbia Circuit. The DC Circuit held that the CFPB didn't violate the separation of powers doctrine. But moving back to this case, the question before SCOTUS is whether the US Constitution allows Congress to create an agency like the CFPB where the agency director is protected from at-will termination by the president, and whether that agency structure violates the separation of powers principles. Appointed by the president and confirmed by the US Senate, CFPB directors may only be removed by the president for cause, meaning inefficiency, neglect of duty, or malfeasance in office. But why this matters, A SCOTUS decision that the US Constitution forbids protecting the director of the CFPB from presidential removal might give the president more control of other leaders of independent administrative agencies. Also, CFPB decisions made under a director with removal protections might become invalid following the ruling. Striking down removal protections for the CFPB director would also make the agency less independent than Congress intended when it was set up. A court decision to strike down the CFPB structure and finding that the court may not sever provisions governing the CFPB structure from the Dodd-Frank Act might invalidate all of the changes to the financial system that are contained in that statute. So lots of ramifications here.
Yeah, definitely. I mean, this has implications for various, federal executive branch agencies, quasi-independent agencies, all of the financial regulations that have been adopted as part of Dodd-Frank. I mean, this case and the decision in this case will clearly have an impact on any and all of those. Now, there was another interesting case where the Supreme Court generally hears cases from other courts, whether they be at the district level or the appellate level, or even from a state Supreme Court. But sometimes the court hears a case from a different source, and that's what's happening here. Is that right, Sarah?
Yes, that's right. So the system that you just described, where the court hears cases from districts or appellate courts or from a state Supreme Court, that's called their appellate jurisdiction. And SCOTUS also has what's called original jurisdiction, which means that they are the first and only court to hear a case. And so sometimes this could be where two states have a dispute, which is what's involved in the case I'm going to talk about. How would any other court hear this case? It goes straight to SCOTUS. And that's what's happening in Texas v. New Mexico. It's part of the court's original jurisdiction. And it concerns a water dispute between the two states, Texas and New Mexico. So basically, the two states entered a compact about river use for the Pecos River, and the Supreme Court, SCOTUS, appointed a river master to kind of oversee that compact, and the river master releases an annual report on New Mexico's obligations under that contract. So the Texas is challenging the river master's 2018 and 2019 report, and they're also challenging some retroactive changes that the river master made to his 2015 report. So the court has to decide, whether the river master was wrong to retroactively change the 2015 report. And it's the only original jurisdiction case on this term.
Yeah, this is really fascinating, and I'll have to admit, as closely as I follow this stuff, I was not aware that there were cases like this that essentially came right to the Supreme Court, and they were the ones that heard it originally. So this is just a real interesting novelty that doesn't happen too often, but it does happen from time to time. So this will be an interesting one to see. Now, we mentioned before that there have not been about 17 decisions reached issued so far by the court, but there have been some interesting ones. So let's take a look at a few of those cases that the court has already decided this term. And Sarah, you had one relating to custody. Is that correct?
Well, it's related to habitual residence under the Hague Convention. So it is an interesting case. It's Monaschi v. Talieri, and the case is from the city. So Michelle Monaschi is an American citizen, and Domenico Talieri is an Italian citizen. They were married and they had a daughter when they were living in Italy. And while that daughter was an infant, Monaschi left Italy, came back to the U.S. with her daughter after incidents of domestic violence, and Talieri filed suit asking for his daughter's return to Italy. So, as I mentioned, it's the case is about the habitual residence clause under the Hague Convention on the civil aspects of international child abduction. So actually what happened was the justices rejected Monaschi's arguments that when a child is too young to know where he or she is, habitual residence can only be established by an agreement between both parents. And addressing the domestic violence claims, the court said the Hague Convention's habitual residence question only determines where custody proceedings will occur, and it doesn't speak to the legitimacy of custody claims.
So this is less about custody and more about just the specific application of this agreement itself. That's really interesting. All right, and then there was another one that you were also thought was interesting that the court had decided. Is that right?
Yes, so I also wanted to bring up Hernandez v. Mesa, which again, our readers and listeners might already be familiar with this case. A U.S. Customs and Border Patrol agent, Jesus Mesa, he shot and killed a 15-year-old Mexican national, Sergio Hernandez, who was on the Mexico side of the border. And the Hernandez family sued Mesa. So the question presented was whether the Hernandez family could sue Mesa under the U.S. Constitution. And SCOTUS ruled that the Hernandez family or plaintiffs like them can't sue U.S. Customs and Border Patrol agent is under the U.S. Constitution.
Interesting. All right. And then Kate, there was a decision that you wanted to talk about as well from one of the ones that they just announced.
Yep, that's correct. This one's hot off the presses, so to speak. Yesterday, SCOTUS issued its opinion for Collar v. Kansas. The case concerns the insanity defense. Specifically at issue here is whether or not the state of Kansas violated the U.S. Constitution by not allowing mentally ill defendants to assert that because they didn't understand that their actions were wrong, that they cannot be held criminally responsible for the actions. Interesting to note here, Kansas is one of 5 states that does not allow the insanity defense. So in a 6-3 opinion, the Supreme Court affirmed the ruling of the Kansas Supreme Court, holding that due process does not require the state of Kansas to adopt an insanity test that turns on a defendant's ability to recognize that their crime was morally wrong. Justice Elena Kagan delivered the opinion of the court. Justice Stephen Breyer filed a dissenting opinion and was joined by Justices Ruth Bader Ginsburg and Sonia Sotomayor.
All right. So we've looked then at some interesting cases that the court has heard and will be deciding coming in the coming weeks. We've also taken a look at some of the decisions that they've already reached, and it's never too early, especially with the schedule being disrupted, for the court to look ahead to next term, which begins in about 6 months in the fall. And my understanding is they have already announced some of the cases that they'll be considering in that term. Is that right, Kate?
Yep, that's right. So the Supreme Court is scheduled to begin hearing cases for October term 2020-2021 on October 5th of this year. As of today, as of this webinar, the court had agreed to hear 6 cases during the term. As you can see from the chart here, 2 of these cases originated in the 5th Circuit. The remaining cases originated in the 3rd, 6th, 9th Circuits, and then the Mississippi Court of Appeals as well.
All right, so the work of the Supreme Court never ends. This has been a really interesting look at the Supreme Court overall, and some of the really interesting cases, and some of the ones that we've talked about, I think will be generating some headlines in the weeks and months to come. So thank you, Sarah and Kate, both of you, for joining me today.
Thank you.
Thank you.
All right, so I hope you've enjoyed this look at the Supreme Court, how it operates, some of the noteworthy cases that they are considering or have considered, and to stay on top of all things associated with the federal judiciary, including the Supreme Court, you'll really want to subscribe to our Bold Justice newsletter. It covers pretty much everything related to both the highest court in the land, the Supreme Court, and it also has tons of information about federal judiciary vacancies, nominations, confirmations, basically an overall total picture of what's going on with the federal courts. So go to our website, search for the term Bold Justice, and you'll be taken to the page where you can sign up and subscribe. Now, we touched a little bit on how the coronavirus has impacted the court schedule, but we also have extensive coverage on our site for all of the aspects of government that have been affected by this outbreak. This includes federal and state policy responses, closures of courts at the state and local level. There's been election changes and school closings on a statewide basis. And this has touched pretty much every branch and level of government, and we are tracking them all on our website. So if you go to www.ballotpedia.org, you'll see links on our overview page, and you can access all of our coverage and resources on this. And it really is just kind of fascinating to keep on top of what's happening. Now, as you know, many elections have been postponed because of the outbreak, but they will resume, and at some point, we have extensive coverage of both the presidential race and then battleground elections that are happening for United States Senate seats, US House districts, some governors, state legislatures. All of that coverage will be on our website, is on our website, and we'll be looking to jump right back into it as soon as we can. And so finally, we encourage you to visit our website at ballotpedia.org for all of the political news. And there you can see our full array of newsletters, including the Daily Brew, which comes out every weekday, and our summary of the week's political news in the tab. So thank you very much for joining us. Have a great day.